Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Sentier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Good morning, or good afternoon, or good evening, everybody. Welcome to podcast number 9 with Maggie Hemsworth.
It's 8.
Actually, it's 8. It's 8, just to be picky.
Gosh, who is counting between friends how many podcasts we've done?
True. We shouldn't count. But it is 8.
Yes.
Well, Tim says it's 8.
It is.
Absolutely. So, I am told now. So, welcome to podcast 8 with Maggie Hemsworth and Dr. Tim Dodsworth and myself, Séverine Sentier. And we are going to talk about a wonderful case, Green versus Betfred. So Mr. Green quite likes to gamble online, and one evening he plays for about 5.5 hours online with Betfred after midnight, and he wins nearly £2 million. So he tries to cash it in, and when he's doing that, he's told that it cannot be done because it needs to be following the normal procedure, such a large amount that it needs to be checked. When they check, they refuse to pay out because there was a glitch in the game. And this is the wonderful bit of the case. The glitch was such in the software that when you play continuously, the odds are getting better. Mr. Green plays for about 5.5 hours. And effectively, had he continued, he would have, broken the bank and he would have won every single time. So, of course, Betfred refuses to pay, saying that their liability is excluded under the terms of the contract, to which Mr. Green had consented well before he played. He had joined Betfred back in 2013. And the dispute ensues. So here we are. The Mrs. Justice Foster replied that in fact Betfred was not entitled to rely on the exclusion clause, that the exclusion clause the clause that they were trying to rely upon did not really cover what they were trying to exclude. Even if it had, it was not properly incorporated. And in any case, the Consumer Rights Act covers Mr. Green. So here we are, very Tarantino-esque facts. Mr. Green playing after midnight for 5.5 hours on his phone. Here we are. I love this case because of lots of different reasons, but I hear Tim is going to disagree with me. So a lot of happy discussion we're going to have. A fair decision, the right decision. What do you think, Tim and Maggie?
Yes, I think it is a fair... I think the outcome is undoubtedly fair. For various reasons, but it's quite a laborious way of getting there.
No, we're not bothered about whether it's fair. We're not bothered about whether it's fair. We've not used that word. It offends me.
It's the right decision on the facts.
Is it just?
It's both
right?
Just and right, I would say. However, it's a very laborious way of getting there, and I think in part the tests that the judge uses aren't quite right. But I think we'll get to that later on. So in short, I think my answer is for now, yes, it is.
Okay, Maggie?
I think it is the correct outcome. Points that are being made, I think, are the correct points to be made. I think, Severine, when you mentioned to me about it, you weren't that happy with the sequence of the points made. You thought it was a little strange to start with the interpretation of the terms and then secondly look at incorporation.
Well, it's not that I disagreed. It's just it suddenly dawned on me that's not how we teach. And I think, for our listeners, it's actually quite interesting. We tell our students always do things logically, and there is no point in interpreting the clause if it's not incorporated. So
yes, but can I just offer this as a thought? Yes, we do teach students that sort of hurdle approach, that the first hurdle that you have to sort of get over, as it were, physically, is that are these terms incorporated, which is the jargon for is it part of the deal at all? And then secondly, if it is part of the deal, what does it mean and does it apply here? But you can see in a sense, when you think about it, on a more sort of deeper level, all right, we're talking for students who are very new to contract law, but at a deeper level, when you sort of drill down and look at a case, for example, like Interphoto Stiletto, where Lord Bingham is saying the more onerous and unusual the term, the more that has to be done in order to bring it to the reasonable attention of the other party. Can you see where I'm going with this? In a sense, you have to look first at the meaning of the term to understand whether it is onerous or unusual. So in a sense, that sort of first question, incorporation, second question, interpretation or construction, yes, that works most of the time, but it is not wrong, is what I'm trying to say, to look at the two together in a sense. And that, I think, is what happened in the court. That they were first looking at what's the meaning of all these 24 pages of text here that Mr. Green just simply clicked on and got going with his gaming habit, as it were. We have to unpack that as we try and unpack the case generally. We have to unpack the meaning of that before we can try and work out, had Betfred done enough to bring those particular terms to Mr. Green's attention. So they're sort of very closely related, I suppose, is what I'm saying. So it's a pedant's point that I'm making.
I agree with you.
I agree. I think if we ask the question of does it even cover the breach, and if it doesn't, then I guess we don't even need to talk about whether it's part of the contract or not. So in that sense, I think that makes complete sense. But I mean,
that same simple question, Tim, is exactly the same for incorporation. And I've said this to students time and time again. If it is not incorporated, game over. No pun intended, but that's the.
But I also think what it highlights, and the reason why I asked the question, it's because then the way we teach, we use the law, but of course we teach a little bit in steps and silos to try to break everything down. But it's nice for everybody listening, whether you are students or whether you're just interested into what we have to say. It's really nice to see that actually we have to teach in steps, but in fact those steps are often intertwined. And so therefore, absolutely, chicken and egg, which one, indeed, game over, no pun intended, but I will repeat it because it's a good one.
It was a good one.
Indeed, if it's not incorporated, but if it is an onerous term, and therefore it needs a higher standard of by Betfred here. Therefore, you need to actually know whether it is an onerous term. And when
you talk about steps, Severine, this is to underline for students listening. This is the game that's analysis. So when we're talking about steps, we're really talking about analysis, which is sort of like dissecting the problem out into its component elements. So these are just techniques to try and help you with that. But there was something else, Tim. You're not happy with it in terms of its reasoning then, or what?
Well, hello, this is Future Tim interjecting briefly. The discussions after the podcast continued, and so our positions may have changed slightly in terms of what you're about to hear. We're keeping the podcast as it is because this is only one small point, but we do want to add the health warning about how we characterise the law in a bit. The position I take about incorporation by signature being essentially the nail in the coffin is more correct than we might assume in the next few sections. There is a new case that's just been decided towards the end of 2021, which is Blue Sky Solutions and Bee Caring Limited. Here the judge confirms, for one, the position about incorporation by signature, but goes on to question whether this should be true where the incorporation is by signature and by reference. A very interesting case. So this podcast is very much a snapshot of what we believe the law to be, rather than a clear statement on the law. I will hand over. Please continue to enjoy. Yes, so if we start off on the incorporation point, we'll get. I think we can get to the interpretation in a moment. I think particularly in light of the Consumer Rights Act, but let's kind of jump in at the incorporation point. When we click on a button online, if I understand Law Commission and so on and so forth correctly, that's the same as a signature, is it not?
Ms. Foster made the reference that effectively it's a click wrap, and online, by the fact that you click on I accept, that's it. There is, incorporation and, yes. So it is an acceptance. Whether
well, it could be. I think, just to be pedantic again, it could be. But that's not the end of the story, is it? And that's what came out of the Green case. Simply clicking on 24 pages doesn't mean that all of those 24 pages have been incorporated. It's a prima facie working assumption, if you like.
Yeah, no, absolutely. I mean, I'm
well, no, actually, I disagree with that. And this is part of where I disagree with the case, because it wasn't the Strange and Graukorb pretty clear that the onerous test, the interphoto test, doesn't apply in cases where there's a signature, unless you're going down the non est factum kind of route. As far as I understand it.
We're not But here, so because of what you said, does it amount to a signature? I think we need to, this is not a formal contract, yes, and so therefore I think we need to disentangle, the signature from the acceptance, because I think they are, different. And here, when you mean signature, I understand it to mean that it has to be signed formally, and therefore that brings to me electronic signature, and to me that's a different thing. But maybe, Tim, I misunderstood what you said. But what do you mean by
thought clicking I accept on the terms and conditions was the same as a signature. I don't think there's any formality over and above, and that is one of the big issues.
Yeah, well, I would agree with that, but my beef is that's not game over, to continue with the pun, because you have to drill down into more detail. Otherwise, we wouldn't have an argument about the detail of these terms. If 24 pages and simply click, that's it, they're incorporated. Well, that's not the end of the story,
because then we go to interpretation.
Some of those will be straightforward terms, and even before that, but some of them will be straightforward terms and some of them won't. And I don't think automatically displaces what Lord Bingham is trying to say. The more onerous a particular part of those 24 pages, then perhaps simply just the click wrap, as you referred to it, is not enough.
I agree, and in fact that's what Mrs. Foster says, that actually it is not, precisely because, and I'm going to use another wonderful word that Mrs. Justice Foster uses, that the contract is full of infelicities. Here, the clauses are, weird, obscure, they are opaque, they're not very well written, they are hidden. You need to do lots of different clicks in order to find it. And so as a result, I think that confirms, the intertwined aspect of acceptance, which I would use rather than signature, because signature is too formal for me. Acceptance is enough, surely. Consent is given, and so therefore that is the acceptance of the offer. But of course, as you said, not the end of the story. It needs to be formally shown that they have accepted those terms, that those terms were therefore sufficiently drawn to their to Mr. Green's attention, and in here they are
All
not.
the cases that we've got on the owner of Thornton and Shoe Lane Parking, Parker South Eastern, wherever, all of those are incorporation by notice or reference. None of them cover incorporation by signature. And there's a good theoretical reasoning behind that, in my mind, is that once you sign, you give up that right to actually check the terms, which is much more difficult if it's a notice in a shop or if it's somewhere else. Now, there is an argument I think we can make, is that if we are saying that each contract every single time is when you click on the bet, in other words, then it would be by notice rather than by signature, then there might be an argument. But I don't think that argument is properly made in this. Also, we should circle back on that lovely word. I mean, that you don't get that very often, do you? In Felicity, you don't get that very often, do you?
No, it's a rather quaint old English word. I looked this up. This is Middle English word for anyone who's into, I think it's etymology, something like that. Dates from the 14th century. And actually, there's a pretty girl's name, Felicity. There may be a Felicity out there listening. And Felicity means happiness. So if you say something is infelicitous, or it's a rather odd way of saying it, but it's unhappy, or that was its original meaning, and it's become kind of like understood a little bit broader than that. So inappropriate, in the wrong place, perhaps. And so the learned judge is using it to try and say the drafting of this is unhappy, might be a more modern way of saying that. So
I would assume the solicitor.
Well, yes, quite. When I looked at that, she's really saying, Betfred, you got to go back to the drawing board, lads, because these 24 pages, some of it in uppercase, some of it in lowercase, some of it in font 8, some of it in font 12, with spelling errors, a lot of it unnumbered, a lot of it with no side headings. Forget it.
In other words, change your solicitor.
Yes, so do you see, Tim, that your argument about signature is just too blunt an instrument? Because it would.
But it was. That's why we have the Unfair Contract Terms Act. That's why we have the Consumer Rights Act.
No, it won't pass muster with the common law, let alone the Consumer Rights Act. But I think the Consumer Rights Act would just kick it into the long grass, that sort of argument. Otherwise, traders could produce 300 pages of close text and say, here, sign that, end of story. That can't be right. Even the common law would balk at that. The power of the signature, yes, is a forceful one. I accept that so far, but it is not end of story. No more argument simply because you've pressed a button, click accept, or you've actually put your name in blood or ink on a piece of paper. It's forceful, but not the end. That's my view. I'm sticking with it.
Just so that we clarify what it is that we are talking about for my little brain, when you say incorporation by signature here, Tim, you're referring to the Lestrange and Grocop case?
Yes.
Okay. So yes, I agree with Maggie.
Good woman. Good woman.
That makes a change.
Well, there you are. You're outnumbered, so it's the tyranny of the majority.
As always.
It's the,
I think
the monstrous regiment of women.
I think in the
felicities of this world, we are happy, and let's show him that we are infelicitous towards him. Yes.
No, he's a nice lad.
With such a beautiful
he's just
world
wrong on this point.
He's just wrong. He's just wrong. No, well, okay. I think though that the common law does step in. The common law steps in with the construction and interpretation point. And I think that's where we step
well,
in.
I think the common law would have something to say at the incorporation stage. But
We're just going round in circles.
Really, as to the extent of the help that the common law can give someone like Mr. Green, I think that's what we're arguing about.
Right. Shall we move on to the interpretation point then? Where do we stand on that? Actually, the point that really interested me, actually there were several points that really interested me. One of them was this idea that was brought up quite often, is the layout of the document adding into the transparency of the term. Now, I've always read, to be honest, and I don't know whether this is a beef or whether this is actually just quite a good idea. I've always read Section 64(3) of the Consumer Rights Act on transparency to mean that we're looking at the term itself. Is the term transparent? But
no, it's
actually quite interesting to say, it's the whole contract. But I think Section 64(3), and I've not got it up in front of me, does actually refer to the transparency of the term. But I guess the term happens in a context. It does, and we can take into account that context. That's good.
Yeah, okay, but again, the common law would say you can't just simply look at a term in isolation. And we don't do that with construction or interpretation, do we? We would teach students that's very wrong to because the judges repeatedly say it's not the parsing of words. You wouldn't look at a simple word. You have to look at that word, that phrase, that sentence, that paragraph, that clause. It is like circles, a sort of ripple pond. With a stone in the middle, as it were, casting these ripples out and out and out and out and out, and you keep going to the four corners of the contract, and you will know that there are some instances when you can go outside the contract to the background factual matrix and so forth. So I think the common law would support the Consumer Rights Act, and I'm sure there's any consumer lawyers out there would know better than me that there will be decisions of the Court of Justice of the European Union that say that transparency is not purely about the understanding of a word or phrase. It is to do with things like the font size, the legibility. I mean, it uses the word legible. It needs to be legible, actually, in Section 64, I think. Its position in the whole document, to avoid traders burying the onerous, difficult stuff at clause 648B.
But isn't that Section 64(4)? Now we're moving over into the prominence.
You were talking about
so whether the term is prominent or not, and I would say that doesn't really. I think you've gone possibly a step too far there in pushing transparency into prominency. Burying the term means that the term is not prominent, and I think that's Section 64(4). Well,
transparency talks about legibility, and do we simply mean in a very narrow meaning of the word that simply means that you can see and make out the letters, that it's not so faint as to be unreadable? Does it have only that very, very narrow meaning? And I would suggest, but I'm not a consumer lawyer, that the CJAU would take a very broad, purposive approach, because that's its normal modus operandum, isn't it? To look at a really sort of a general things.
What's the point of having Section 64(4) then? I mean, I think we do have to give each of the sections their own space, as it were, to work.
Yes. So, well, don't you see that prominence, in a sense, could be the sort of functional equivalence, to borrow Lord Bingham's phrase, that he would have used in Interfoto Stiletto. You know, you're drawing sufficient attention to it. Now, you draw sufficient attention in lots of different ways.
So you're making my point beautifully. Therefore, I would tend to agree with, Tim's point here.
What?
I'm edging my bet.
What is this?
Agreeing with each of them so that I don't I don't get the wrath of either.
Or both. You get the wrath of
Hedging my
both
bet.
now.
You hear
Severin.
that? Another pun. Hedging my bet.
We really are.
We're doing well in all these really, really weird. No, but therefore, in a way, that they are all interrelated.
Yes,
because
I
like
agree with that.
Tim, they are, transparency, prominency. We go back to the beginning. Is it an onerous clause? And if so, has it been? So it just shows how everything is interrelated.
Yes,
here.
I agree.
And it is true that I think when I read the case, we've all been we've all been teaching law for a while, and I think one lesson to me is that I still get surprised by I hadn't quite thought about it in those terms. So I think that is I had a similar reaction to Tim here. So and it just makes you think, and therefore it just makes you analyze again, and that's great. I love being surprised by things which I think I know completely.
Well, one of
inside
the
out,
interesting
and I
things,
don't.
I think, Betfred must have thought, perhaps like ordinary folk might think that don't know anything about consumer rights, that if we put the terms that we're really bothered about in uppercase, it's going to stand out. But actually, that ended up as being something of an own goal to sort of come out of gambling into football for a minute.
No, but I think that I think Justice Foster did make the point that actually that was not enough. Clearly,
I think I would go further. That can make it worse in a sense. When in the old days when email got going and we were sort of taught sort of etiquette of using email, and these days if you put stuff in uppercase, it looks like you're shouting at someone by email. And that's what Betfred in their minds thought. Well, we were shouting this because this is the very important clause to us. But the judge is saying, actually, that just makes the readability, that's a made up word, it's horrible, but you know what I mean, of the whole thing so much worse. Because you've got bits of it in uppercase, then suddenly you go to lowercase, then you change the font, then you've got a side heading here and God knows how many sub-clauses there. The whole thing becomes unmanageable, if you like. And in a sense, what she's trying to say to people like Betfred or their lawyers is really that acronym that sometimes barristers use, KISS. So keep it short and simple. In fact, you could add another S, stupid. Yes, keep it short and simple, stupid. And that's really what they should have done. And they've made it far too long, far too unwieldy, uppercase, lowercase, all the rest of it. Just made it worse, not better.
Yes. There were lots of infelicities, and that's part of the infelicities.
Felicity again. Felicity, come back to haunt us, yes. I don't think we're really disagreeing about this, other than the power of the signature. I mean, that's a small point of detail kind of like between us at the moment, that I don't see it as powerful as Tim does, that's all. But he'll come back with some case to prove me wrong.
You know I will. You know I will.
There is the gauntlet thrown down.
Another...
What else do we like about it?
Can I ask another question? Because I forgot to mention at the beginning that it was, a summary judgment.
Yes. Oh, civil litigators out there, you'll be into this. This is part 24, civil procedure rules. Magna Carta, how about this? If you don't like the modern stuff, I'll give you 1215 for you. There's a bit in Magna Carta that says justice shall not be denied nor delayed. Now, summary judgment is about that, in a sense. It is the ability to get a very swift judgment on a point that does not require the expense and the delay. You can see where justice denied and delayed is coming in now, of a full trial, which might be 2 years down the line. So for many years, people as old as me will remember Order 14 of the Rules of the Supreme Court, but now we've got Part 24. It's the same damn thing. So this summary judgment is, I make an application to the court, I say, this is simple, this is straightforward. We don't need, in the interest of justice, a full trial. Give me judgment now. So Mr. Green's smart lawyers said, this is the swift way to get your 1.7 million, my lad. We will go for summary judgment. And that cuts out probably 2 years and God knows how many pounds.
Yes, I was. Okay, so can I ask a question? Does that mean that Betfred still has to pay the cost?
Yes.
Haha.
Yes, but there's the upside. There's a small upside for Betfred. Obviously, the costs at the Part 24 stage, we're talking 2 months into a civil proceedings rather than 2 years. The costs, they have saved themselves some money in legal costs.
Yes, even though Betfred was the one to contest, the need for a summary judgment, saying that it raised the important question, and so again.
So what they're trying to say is, don't give judgment against us yet. We've still got some arguments. It's desperate, I think. But anyway. We're still in the game. If I'm continuing with these puns, we're still playing the game, as it were. Don't shut the door on us yet. And that's another aspect of Magna Carta, justice not being denied. So if they did have reasonable grounds for a defence, for an argument, then they should not have had a judgment entered against them. But when you look at the facts of this is primarily not a factual dispute at all, where it's one person's word as against another. That's the sort of arena where you probably should, all other things being equal, have a trial. This is not like this. This is pure contract law. This is why it's manna to us, as it were. A point of construction, a point of law, some arguments about the law of mistake, which we've not yet talked about, and that is just so appropriate, amenable to summary judgment. So it was right procedurally, as well as right outcome, I think.
Yes, no, that is indeed very good, and I quite liked. I don't know Mrs. Foster, but she's Mrs. Justice Foster, but she seems a very mistressy kind of person. No, don't give me that. It's all the arguments have been swiftly
my love,
with.
because A, she is a woman, and B, she's a litigator, and C, was a barrister. So those three things combine to make her a no-nonsense sort of bod, I would say.
Yeah, no, I quite like the approach.
Although a few more cases wouldn't have harmed.
I know. I was going to say, it's funny how when you look at it,
it's not her job. Remember, to come up with cases. It's the advocate's job to present. This is the English system, not the French system. Or the German system.
Even worse, though, isn't it?
She is the umpire in a sense. We still have that kind of cultural approach to civil litigation, coming off contract law a bit, and I'm putting my civil litigators lecturer's hat on. But anyway, it's down to the advocates to draw to the court's attention relevant case law. It's not her job.
So one thing that I was wondering, I'm not quite sure I've understood all the technical terms around this, but as I understand it, this was a programming error, wasn't it?
Yes.
Effectively. So So it's I thought it was really interesting. They even tried to argue that the term software could incorporate this, because surely here the error isn't in the software at all. It's far from the software was doing exactly what it was told to do. The programmer got it wrong. So I'm really not quite sure why they even brought that in.
From a practical perspective, I don't know anything about these particular parties, but the software, if you look at the case report, was devised out of house, as it were. It was not.
Yes.
It was not Betfred. It was a third party. So you're talking about Betfred's financial outlay through this.
Yes.
In strict legal terms, they would have a very good claim.
Absolutely, I think that's
cut
fine.
And shut, really, final against the software company. But we don't know anything about the financial position of the software company. Are you seeing where I'm going with this? And so they may have difficulty passing that on, they would have probably somewhere in the documentation a contractual right of indemnity against the software company whose error this is.
Oh, I'm sure they.
But it's one thing to say you've got a claim.
Lawyers, I'm sure they're going to.
It's another thing being able to extract the money.
Yeah, exactly. That would have been a neat way of blaming it on the software.
Well,
and also because
they're probably doing that in the background, but you'd not be privy to that in these particular proceedings unless Betfred seek to join the software company into the proceedings, and they've taken a view about not doing that, trying to keep this clean, if you like, and simple.
It is interesting on this too.
Before we bounce off to common mistake, and which obviously I also have something to say, we can't have a case with mistake and I don't say anything.
I know, but it was so short.
No, dear listener, I've got to say now, dear listener, Tim's hot topic is the law of mistake. So we can't end this podcast without talking
absolutely
about
not. But we're keeping the best for last, aren't we?
Do we?
Section 62. Severin. Section 62(1) of the Consumer Rights Act, the term to be unfair, where it creates an imbalance between the parties. I mean, effectively, as far as I can see, these terms and conditions are essentially giving Betfred a discretion on whether they want to pay out. I mean, that has to be, that creates an imbalance, right? And not just that. What Betfred are doing is they're shifting the consequence of an error in the software or in anywhere, actually, not anything. They're shifting that risk that the consumer can't control in any kind of way. They can't check whether the software is working right. They're just shifting that risk over onto the consumer. I mean, both of those, to me, are signs that this has to be, that this has to create an imbalance which is contrary to the requirement of good faith. I mean, we're not going down the good faith rule here. We don't even need good faith.
And I mean, if you look at the schedule, there is a schedule, isn't there, in the Act for people who are really keen on the Consumer Rights Act. I don't know if any listener here is still with us, but if you're really keen on consumer rights, my loves, you need to look at Schedule 2. There's a list of illustrative types of terms, and I think, Tim, you might, if you'd been the advocate there, if it had got that far, you'd probably be trying to draw some analogy with some of those on what we used to call the grey list, if you like, these sort of obviously or more obviously dodgy terms. That may be unfair, yes. Quite likely.
As opposed to the red list, or was it blacklist? No, blacklist, I think. Blacklist are the terms that are unfair and may be unfair.
I don't know whether I would call it a contractual discretion here. I don't think that's, that kind of, because it was an exclusion clause. So, I mean, maybe, that there is perhaps an interesting parallel. And I think, again, Mrs. Foster did say at some point that, if it reduces, liability so much, it's quite serious. But I think that's not a contractual discretion as I understand it here. But maybe that just, maybe I didn't read carefully enough. But I agree with the last point that, that you make. There is clearly, they were trying to put the odds into their favor. Another.
Oh dear.
Yes, I suppose I agree with Severin here that there is a sort of, in some instances, quite a fine line possibly between a term that gives someone a right of choice, and you use the word discretion, and one which is excluding liability. But as a matter of construction or interpretation, you would have to find liability first, that there exists liability in order to then see that the term is then coming in at that point to exclude responsibility to pay anything for that liability.
Because if it was a contractual discretion, I think it probably would have been easier for Betfred. So I think that's why, it's not a contractual discretion as we understand it, because of course the
No.
term contractual discretion, because then we don't need to worry about here whether it was in the contract or not. So, but I hear again another little lighting up in my brain that's another interesting parallel between all these all these tools that are at the court's disposal to check that the contract is or the contractual process as well as the contract is fair and equal. And I think here, looking at some of the expressions that Mrs. Foster used, she clearly was happy to give judgment for Mr. Green.
I think it would be very hard to say it was a discretion, because that's sort of getting at the whole heart of the contract of gaming.
Yeah.
You don't put money on that X horse will win the Derby, and the deal isn't that you will only be paid whether the horse wins or not at the discretion of the bookie. That doesn't sound like much of a contract on that basis.
Well, I'm sure there was a term in there that I read that was along those lines. Whether or not they relied on it, I don't know. But I seem to remember something around the paying out part that was a discretion. But I can't. I'm honestly I can't find it. So maybe I dreamt that last night.
But
this is possibly coming back to the infelicities of the contract. If a lawyer is having difficulty remembering or finding a particular point, and you've got God knows how many years training in law, we assume Mr. Green is a better gambler than he is a lawyer. And therefore, that comes back to the point about the average consumer, which I think you were looking at section 64. I think it was you, Tim, a few minutes ago. You were talking about section 64, and it's there which they've got this idea of average consumer.
Average and informed.
Yes.
Yes, I love that expression.
Who's reasonably well informed, observant and circumspect. So it's about this prominence, bringing it to the attention of the consumer. And who is this consumer? The average consumer is someone who's reasonably well informed, observant and circumspect. I had to look that word up as well. It's sort of careful.
Yes.
Cautious.
Well, yeah.
Diligent.
Yeah. Gambling on your phone at midnight for 5.5 hours. I won't say anything.
Well, I suppose Betfred could say to that point, Severine, we don't control when people gamble or for how long they're gambling.
No, clearly not.
This has to be a set standard, which is applicable morning, noon or night, as it were.
Yeah. I'm sure they have tightened that up. I was thinking, shall I try? But I thought, no, it's probably too late now.
Yeah, no, I think they realised very quickly.
It is funny. I did wonder.
Very quickly. Otherwise, there would be other claimants.
Yes, they would.
Like Mr. Green, and I think it was just the fluke, in a sense, of the situation.
Yes, it is.
That, as you said in your intro, Severine, the guy had been playing practically all night.
Yeah.
And I don't know much about the world of gambling, but the number of people who do that must be relatively small.
Yes.
And the number of people who would continue for 5 hours at a stretch must be even smaller. And then they realised, as soon as Mr. Green rings them up the following morning, that they've got a problem. Because
3 jackpots in 3 seconds, I think.
Yeah, whereas I can't remember the stats now, but the odds that they were working with were infinitesimally small.
They were.
0.000 something or other.
Yeah. Yeah, no, that was lovely. Okay, so team, mistake, which Mrs. Foster just got rid of it almost instantaneously.
Well, don't you think this was a bit desperate?
Yes, I think it was.
This was a desperate
Yes.
attempt on the part of Betfred, wasn't it?
I think so.
But again, I'm not sure. I'm not sure about that. I mean, yes, I think in this instance, yes, you're right.
Oh.
Don't say that very much, but yes, I agree.
Sorry, Tim, repeat. I didn't quite hear that. What did you say?
I've
But
forgotten
you're not
already.
happy with
I think
it.
I
You're
made a
not
mistake.
happy with it, nonetheless.
I think the reason I'm slightly more cautious here is let me tell you why I think it was possibly not the right ground on which it was dismissed, because I think the ground that really should have been picked here was the fact that one party has taken responsibility, and that is quite clearly Betfred here. If we look at cases like McRae and others, they have led Mr. Green to believe that everything was fine. There was no reason
just
for him
to argue the toss with you, to play devil's advocate, as it were. McRae is a bit different and could be distinguished by some smart lawyer, I think, because in McRae, remember, they were saying to people, look, there's a sunken ship. Who wants to come and salvage it? Yeah. That is an explicit. They were saying something very explicit, weren't they?
Yeah.
And so it would enable a court to say implicitly, you are warranting or promising or suggesting, if you don't like any of those quite strong words, that there is a ship to be salvaged.
Yeah.
But that was much more explicit, whereas in the Betfred case, you haven't got anyone really saying anything. There is no particular words or conduct. It's just in the background, perhaps Betfred's assumption, for sure, that there isn't this, you referred to it as glitch, I would say error, fault in their own game. Mr. Green wouldn't have given it the first thought, I'm sure.
But that's what I mean. So they've clearly taken responsibility. He's quite right in not caring about it, because it's
yes, but be careful
really
with this taking responsibility and using McRae, because I think McRae is a bit different, because something was actually said. There is a ship to be salvaged, whereas Betfred are not saying anything.
Okay, so let's take the great piece.
So what
then.
would they have
said,
Tim?
Well, by putting up the option to bet, right, on their website, they are essentially warranting that this is fine,
because that's a promise. That I don't think there is enough there.
Okay,
for a promise and assurance
assuming that each time there is
with our game.
Well, exactly. There was nothing wrong with
it. There was nothing wrong. They're not saying play for 5 and, play because there was a programming error with that they hadn't thought that, anyone would play for longer than, I can't remember. So it's not as if they're saying, I don't know, I can't even get my head around, how else was it that there was no mistake? That mistake could not possibly be, it's not as if they're saying, we guarantee that, if you play for, longer, that the odds are going to, I don't know.
Well, the problem with mistake is that they were trying to argue as the only ground of mistake that they could possibly have argued, but it was desperate, as I said a few minutes ago, common mistake. So there is an assumption, they're saying, on both sides that this game does not have this software error in it. But when you sort of look at that closely, that is only the assumption of Betfred. It's not the assumption of Mr. Green at all, or anyone like him playing that night, or indeed any other night. I agree with you when you talk about responsibility, but not in the sense of a warranty here, Tim, but more in the sense that, remember, for the sort of law of mistake to kick in at all, this thing had this problem, as it were, this assumption of facts, which it turns out to be
yes,
true,
that was the
false,
wrong word. Apologies. Yeah.
must not be the responsibility
Of
of
either
either
party.
party. So that's where responsibility comes in, I would say. Not a warranty or assurance, as was happening with McRae, but because, as you're suggesting, really, but I'm
Exactly.
casting it in a slightly different way, the software, the only party who had control over the software is surely Betfred.
Well, actually, technically,
And therefore, the fault
Yeah.
is theirs. Yes, okay, the subcontractor. But between Betfred and Green, it is only Betfred. Are you with me? It is not something
exactly my point.
outside
Yeah,
of the
yeah.
parties. And that's really what the law of mistake is trying to get at. Just like the law of frustration. The sort of, they're sisters here,
Cousins.
or kind of like siblings at any rate. They are
Yes.
all right, cousins. They're
two
similar in that
sides of-
sense. That this thing has gone amiss is outside of the control of the parties. And this mistake, if we use it very loosely, this error, it was wholly within the control of one of the parties. That's why mistake won't work here, I would say.
Exactly, which is a much better ground than the one that is actually being argued, which is by the impossibility aspect. And I think there again, the impossibility isn't. They don't mean literally impossible. What they're talking about is frustrating the commercial.
Again,
the commercial
they're fixing
purpose of the
on
venture.
Betfred's commercial purpose, but that's not really the question. It is the combined commercial purpose of people like Mr. Green on one side and Betfred on the other. You can't focus on one party's commercial purpose for the law of mistake. It's this combined thing that has resulted in this contract. It's entirely workable from the perspective of Mr. Green and people like him. And indeed, he was quite happy to play and kept playing and won 1.7 million. He would say nothing wrong with it. Great. It fulfills my commercial purpose.
So that point I don't think is. I think you could cast it in different terms on that point. I think the risk allocation, that should have been the point that they were trying to make, and I think that would have worked a lot better, and that's nail in the coffin. It's over. There's no common mistake here. But on that point, if we talking about the commercial venture, I mean, you could argue that the commercial venture was a sustainable betting contract. This was not sustainable. Every single time Betfred was going to lose.
That I don't think that's strictly true on the facts. Had Mr. Green played for an hour, say, and I don't know enough about the problem, the glitch, the IT problem here, he may well have not have won, certainly not 1.7 million. It was the combination of having paid for 5 hours straight without any gaps.
Yeah, that was the thing. The error was that obviously when they programmed the software, they didn't cater for they didn't factor that in, that somebody would be playing for, longer than 5 hours. So clearly, here the software programmer, whoever he or she is, I would have thought that was such an obvious thing. Actually, I thought that
of these things, we could look at all of these cases
hindsight
and
is
say
wonderful.
with the benefit of hindsight,
absolutely, I know,
this was
absolutely.
obvious. It wasn't obvious at the time, was it?
No.
And don't you think there's another point there about it being obvious? There's another point there about being obvious, that the argument starts with this term excludes our responsibility to pay. Mr. Green is not entitled to the money because of this term in our contract. Yeah. And then if they fail on that one, they come back and say, the whole commercial purpose of this thing is fundamentally flawed and based on a common assumption which we didn't have. The two things don't really hang together that well, because on the one hand, they're saying we have a term that provides for this. And then the next stage of their argument, they're saying, well, there is no term that provides for this. It was simply a common assumption that the game would function in a different way.
Desperation.
Well, I would say that's in the alternative, isn't it?
Yeah, well, they're heading in the same direction in terms of outcome, but they don't really sit that happily, felicitously.
Oh, no.
Is that a word, Severine? One with another, really?
But couldn't we still say? I'm still pondering this point early on. I mean, there is another argument I'm thinking of making if we assume that Mr. Green actually knew about it. But I'll come to that in a second. I mean, the question is the contract without the quality, right? The mistake, something
No,
which is
only from
different.
Betfred's perspective is it essentially different. It's not different in the abstract. Or in their combined contractual arrangement, it's Betfred that views it as being an entirely different game because the odds are so much stacked against them. If there is a player who plays for X number of hours straight without any gaps, without going to the loo, without closing his laptop, without stopping one game and starting another, this was continuous gaming, and that is a significant point, I think. So there weren't thousands of Mr. Greens who won that night. I think it was a one-off,
good for them,
as it were.
Yeah.
Yeah, all right, they go off light then. Have we persuaded you? No, you'll come back with something else. This is sport.
It certainly is. It certainly is. I just don't think. I mean, my point was, yes, I agree that is a point, but out of the elements we could have taken in this case, it was not the strongest. The strongest argument was the risk allocation in this particular circumstance, I think. And I think the heavying on it being something essentially different, yes, that argument can be made.
Yeah, I know, but if
you're
the advocate for Betfred, where are you going with that? Because you can't say much about risk allocation because the risk allocation is with you, with your client. So,
well, exactly. You wouldn't say anything. You would try and leave it all out and just say, well, there's a common mistake. I'm thinking more for Mr. Green that their main emphasis should have been on one party Betfred taking responsibility here, rather than relying on that it was impossible or something commercially.
Yeah, well, I don't know. Do they say impossible? But they're saying commercially.
Yes, they're heavy and tiny.
So different as to be a different game.
Well, they actually use the word impossible here, and I think that's a misreading of. I think they take the quote from the Great Peace Shipping, and then heavy on that impossibility aspect. And I think there. Actually reading the Great Peace a little further, and I think it's in paragraph 82 or somewhere further down, they actually clarify the impossibility point, and I think they may have overlooked that.
Meaning commercially different.
A pedantic
radically
commercially different rather than impossible.
Because impossible is rather an extreme stance, isn't it? So they've rode back a bit from that to say it's commercially an entirely different beast, if you like. This is not the deal that we made. Implicitly, it's a different animal entirely. That's
and I think that's
getting at. I think
if I remember the Great Peace correctly, I think they're making reference then to Hong Kong fur actually in terms of how they would read the terms. And they use the example of the one that we all know with the lease of a room with a view to the procession, but there's no procession. That's the commercial venture.
So the question
it's not impossible.
Is this a lease of a room, or is this a lease of a room with a view? And you're trying to make the argument that those two creatures are fundamentally different things.
Yes.
And what's difficult, don't you think, with the law of common mistake is the heart or core of the deal tends not to be explicitly made out. You're trying to divine that as an inference from the whole basket of the terms what really is the subject matter, the purpose, the crux or core. I'm trying to think of different words. It's really the same sort of thing. But it's so hard to put your finger on it because there isn't a particular term or word or phrase that a lawyer can alight upon. You have to stand back outside of that if it's in writing and ask yourself, okay, what's this really about? What is the guts of this deal?
Exactly. And the question is, do the odds feature within that? And I don't think it's quite as clear cut as a judge makes out.
So what you're saying is they could have made a better argument, a better fist on the mistake point, and could have put that at the forefront of their arguments rather than these 24 pages of rubbish terms.
Exactly.
So are you saying that they thought, so because of the glitch, the contract was fundamentally different because they were exposed to a higher risk of having to pay out?
Yeah.
Again, I don't think that argument would actually succeed. But I don't think
there's
we can.
a couple of points,
No.
aren't there? There were a couple of problems with that because you're then sliding into.
But that would not be a common
mistake. Is this
mistake.
a quality thing? Is the quality of the thing which is different, and that's a problem, isn't it, for the law of mistake?
Well, not so much for common mistake. For unilateral mistake, that excludes.
No, but the quality of the thing has to be so
term.
fundamental as to have changed the nature of the thing. Now,
that's right.
That's difficult, isn't it? When you're saying the betting odds have got worse, that's a sort of spectrum, in a sense. So you've got to find a line on that spectrum when the animal, the contract that you thought you had, has become a different beast. Are you with me? And that's quite difficult, isn't it, to find where that point might be.
But also that would not work. That would not work for the common purpose, because I would have thought that, they are at complete odds with each other, because the purpose of Mr. Green is to try to win as much as possible, and the purpose for Betfred is to try to prevent them. So in a way, they get a taste of their own medicine. That actually here the odds were reversed and they didn't like it.
Yeah. I mean, the other point the interesting, taking that a little bit further, the interesting point that we might be able to draw out of it is, what if this was a glitch that was happening to every single player? So if you played for 20 minutes...
That shouldn't make any difference to the legal arguments, I would say.
Seems to make the game something fundamentally different.
Are you saying that if it is after 20 minutes, then it changes the odds?
He would have won 1.7 million after 20 minutes, is that?
And so therefore everybody would have won.
Like
therefore the risk...
I mean, it's clear that as a unilateral mistake, this may work if it was an error in displaying it or something like that. Then, and this was happening across the board to everyone. The other party knew about it.
You'd need the other party to be aware of it. So you don't get off base one with that either, do you?
Well, which would be sufficient if it was happening on every single bet, right? If for 20 minutes straight, you were only winning.
Machine, spurting out money. Yeah. How would you know? I mean, I don't gamble, so I would have thought that, if I win within 20 minutes, big odds, I would have thought, great.
No, that's still not going to work, remember, because unilateral mistake is a mistake as to the term, the existence of a term or the meaning of the term. Even in that sense that you're explaining now, where you're winning the jackpot after 20 minutes and then you play again for another 20 minutes and you won another million, that's not realizing that there is an error in any term. No. It's perhaps an awareness that money is being paid to you by mistake, but that is the law of restitution or unjust enrichment, not the law of contract, I would say. Do you know what I mean? When you're aware that someone has paid you money by mistake, we don't need a contract. We
True.
don't need the law of contract to reverse that unjust enrichment, as the jargon now has it.
And therefore, the analogy of, the
so your cash point that's spewing out money that would be the law of restitution and unjust enrichment. Nothing to do with the law of contract.
That is a clear-cut case that when you ask 20 quid and it gives you
500, you don't run away and think yes, because that's theft.
Compared to me playing for 20 minutes and me winning, the million, it would not enter my mind.
No, you just think you've been very lucky, wouldn't you? You just think you've been very lucky. Yeah.
Interesting. We have managed to talk about mistake for a good while when Mrs. Foster dismissed it in 2 paragraphs.
You're welcome.
That's only the judgment. She may have...
Exactly my point. It deserved more time.
Have we done this to death then?
Let's hope so.
I think it's probably a good time, to stop, because I think we are actually pretty much agreeing with each other. We've argued, can I say we've argued the toss, or is that?
Well, it might be, but I use that phrase. You'll have to tell me to stop using that. No, okay.
Dear listener, thank you very much for. We are now an hour into it, so for listening for over an hour, and if you have held on without pressing the button on...
No, that probably makes it worse.
Listen to us in a quicker way.
It's time to go to sleep now.
Okay.
Night, then, dear listener.
If you've held on for that long.
This is an inference or an implicit warranty, Dr. Dodsworth, that email is mad.
I don't think that would make it much more enjoyable, to be honest.
I don't know.
Night, and remember that you can always get in touch with us. We now have our fancy email address, which is, I think, unpacking.contract.law@gmail.com. If you've got any questions, any ideas, any suggestions, drop them in.
Does someone monitor this email?
Yes, we do. We do, of course, monitor this email, at least before each session. There's a quick glance into the email to see whether there are any interesting questions or suggestions. If there's any cases that really need discussion that you think we should discuss, I think that would be fun.
Till podcast number 9, it is for us. Goodbye.
Bye-bye.
Goodbye.